Thank you, Mahesh. Appreciate very much the opportunity to be here with you today. I just want to echo the sentiments that have been expressed already, and that is, more than ever, if you're not involved in politics, you're out of business. If you didn't see recently, there's now about 1,372, I think, exemptions that have been granted to the healthcare legislation now. 20% of those have been granted to businesses within Nancy Pelosi's district, and the state of Nevada has recently been granted an exemption as well. Ironically, the two proponents, heavy proponents of the healthcare legislation, Harry Reid and Nancy Pelosi, have been involved in granting extensive exemptions. And I can tell you, it's not because their opponents are getting those exemptions. It's those who've supported them, and it's business is about politics, and politics is about business. And I couldn't agree more. You're either involved in politics or you're not. And we're involved in very challenging and interesting times. There are those who think that this is one of the most unprecedented times legally in our country's history. I happen to be one of those. And let me just begin my remarks by just taking you back to this boring subject of American history that a lot of us slept through in high school and college, but becomes particularly pertinent now. In 1774, 2 years before the Revolution, our founding fathers and the people who lived in this country were upset at the King of England, as you may recall. The king had imposed, as we all know, taxes, had imposed various legislation, acts that had originated out of London, the Stamp Act, the Tax Act, different types of legislation that our founding fathers would rebel against. In the shot heard around the world at Lexington and Concord, it would start the American Revolution. 2 years before that event would happen, the colonists got together and said, we are not putting up with these acts. We are not putting up with this legislation that imposes these kind of taxes, that imposes this kind of regulation on us. The taxes and the regulation related primarily to the British goods that were being shipped into the colonies. And much of what the colonists would buy were these British goods. So the colonists sent, the Continental Congress sent a proclamation to King George and said, we're boycotting all of your products. We're not going to buy them until these, what they called intolerable acts, this legislation, was lifted. Well, King George in London didn't like that, and he called in his Solicitor General. We call that person now, and it became known as the Attorney General in our United States. He calls in his Solicitor General and says, this is outrageous. These colonists are boycotting buying British goods now, and I want to do something about that. And his Solicitor General told him, there's nothing you can do about that. You cannot force the British subjects in America to buy a product, to purchase a good. Now you fast forward 200 plus years later, on March 23rd, 2010. You know what the story is. The President of the United States and the Congress of the United States passed legislation that tried to get at a challenging, vexing problem in this country. No question about it. Difficulty in terms of the access to and distribution of health care. Everybody agrees that's a problem. But the way in which the President and the legislature attacked that problem was to enact this Patient Protection and Affordable Care Act. And the hallmark of that act, as you know, is what's called the individual mandate. And it requires every single one of us, all the citizens of the United States, all legal residents of the United States, with limited exceptions, to purchase a product, to buy a health insurance product. And you all know that. You're in the business. You know this stuff very well. And that legislation was not debated. It wasn't presented to the various committees in the House and the Senate in terms of its constitutionality. You may recall it was rushed through. And I don't care what side of the aisle you're on. There are people who are sincere on both sides of the aisle on this point, and I bless them all. But from a legal perspective and from a constitutional perspective, it's a very challenging piece of legislation, because as the Congressional Budget Office itself, a nonpartisan group, said, when Congress went to that group and said, can we do this? Can we fashion this legislation in such a manner that would spread out the risk to everybody by requiring everybody to buy the insurance? The Congressional Budget Office said this would be the first time in history that Congress would ever require an American citizen to buy anything. It would be and its constitutionality was questioned. And you may recall, during the course of this discussion, there were questions about the constitutionality, and somebody asked Nancy Pelosi, a reporter, said, Madam Chair, where in the Constitution do you find this authority? And remember her response was very dismissive. Are you kidding me? Are you kidding me? And when the question didn't go away, she sent her press spokesperson out to say, that here, you can put this on the record. That's not a serious question. That's not a serious question. Of course we have the authority. Well, when pressed, then the Congress identified this Commerce Clause. So within the Constitution, there's a clause that says that Congress may regulate commerce among the several states. They said that's the clause that gives us the authority to require all Americans to buy health insurance. And so that's what now this legislation is based on, the Commerce Clause. And within hours of that legislation being signed, 14 states sued the federal government down in Florida. United States District Court of Florida, Northern District. And you may recall that the governor of Nevada at the time asked the Attorney General to get involved. She said, no, I think that would be a frivolous lawsuit. We're not going to get involved. And so the governor then appointed me and my law firm to go do that. We joined with other states, and now there were 20 states in about May, about a month later, in May. After the November elections, there's now been 6 other states. So now there are 26 states that are challenging this federal health care legislation, and in particular this individual mandate. And the states are doing what the Founding Fathers absolutely envisioned that the states should do. Absolutely envisioned this. You may recall, after the rebellion that I was talking about, and after, through some miracle, we won the Revolutionary War, with George Washington at our head. Now they get together in Philadelphia, and George Washington now is asked to be the president of the Constitutional Convention. Of course, he'd serve as our first president of the United States. He is probably the one person in American history who's the indispensable person, if there ever was one. They go to Philadelphia, and they say, we want to try something different. We want a different system of government, and they call it an experiment. It would never have been tried, it had never been tried before in the history of the world. And they said, we want to limit government. We just overthrew King George, the epitome of centralized government that had everything within his control, the legislative, the judicial, and the executive powers. We don't want that, so we're going to split it up. And of course, we all know that. We've got 3 branches of government. One of the reasons that the Founding Fathers did that was we don't want there to be too much power. We don't want it to be too easy. People complain all the time that Washington is slow and it's not efficient. Thank goodness for that being slow and inefficient. It's supposed to be. The most efficient thing you can have is a dictator or a king. The Founding Fathers didn't want efficient government. They wanted divided, dispersed government that limited power. Why? Because the Founding Fathers said we want liberty. We want freedom. Individual freedom and liberty is more important to us, the Founding Fathers said, than this efficient form of government. And so they divided out the branches of government. And the other thing that they did was, they divided and dispersed out the power of government horizontally, of course, across the 3 branches of government, but also vertically. And that's what we call federalism. Federalism, where you got a federal government and then you got states. And today there are 50 sovereign governments. Sovereign governments. And there's one sovereign federal government. And the Founding Fathers devised this ingenious system of not only dispersing the power horizontally, but vertically, and said the federal government is a limited government. First time in the world's history where we would have a central government that was limited. And how is it limited? What John Marshall said was, and the first Chief Justice of the U.S. Supreme Court said, so that we'll never forget that the federal government's powers are limited, we established and we created what's called a Constitution, and we wrote down what the powers were. And we established the different branches and what their powers were, and the federal government would have to show in that document, in that Constitution, where they had the power to act. What about the states? The states didn't have to do that. Always remember, we were states before we had a federal government. Sovereigns, broad powers at the state level. All we got to do is just pass laws at the state level, get our legislature together and pass laws, and the governor signs off on it. That's fine. But the federal government is different. They just can't pass any laws they want to pass. They've got to be able to say, we can pass the law, and here's the authority in the Constitution that allows us to do that. And so what is at stake here in this litigation is our very form of government. Matter of fact, Judge Vinson, who's down in Florida, when he would rule on this, and I'll tell you about that in just a second, he would rule on this, he would say, this has very little to do, this case has very little to do with health insurance. It has everything to do with our federal system of government, the relationship between the states and the federal government, the relationship between the individuals and the federal government. And so there's this experiment now that was enacted. And I would suggest, I think history bears this out, that the reason that we have been the most prosperous, free, charitable, kind imperfect nation that we are is because of our form of government. And you don't have to look much farther than just, south of the border. Why is it that across the Rio Grande there is poverty, inequality, crime, very limited economic opportunities? Or why is it that across the Egyptian border from Israel to Egypt that Egyptians try to live on $2 a week in wages? And the United States, across the other side, across the Rio Grande, enjoys a high, prosperous standard of living with blessings and opportunities and freedoms to us and our children and our parents and our grandparents. It's because of our form of government. It's this form of government. Is it because we are just inherently better people than those across the border? Of course not. Do we have better character? Do we work harder? Are we more moral people? No. It's our system of government. And so what's at stake is this system of government that was established by our founding fathers. That's what's at stake here. If, in fact, the states no longer have this broad power, and we call that police power, broad police power to regulate the health and the safety and the health, safety, and welfare of our citizens. If the states no longer have that, and now the federal government has that authority, which is what the states have argued in this lawsuit, that this lawsuit is unconstitutional for several reasons. One is, Judge, that the Commerce Clause does not allow the federal government to require anybody to buy a product. That's our first line of attack. The federal government is just wrong. It's never been used before. The Commerce Clause has always been used to regulate somebody who's already in business. That's fine. If you're in business, you're voluntarily engaging in a business activity, Congress can regulate you. And across the state lines, Congress can regulate you. But what Congress is doing here is they're forcing us, the states have argued, into commerce. I'm just sitting in my house watching TV. I don't want to buy insurance, right? I don't want to get involved in this product of a healthcare insurance. But I'm going to be now told to buy it, and now I'm going to be regulated because I'm buying it. First time Congress has ever done that. No question Congress has broad power in the Commerce Clause, but it's always when you're voluntarily engaged in business. For the first time now, Congress is going to force you and me to get involved in a business and regulate us. And so we say, Judge, that's just unconstitutional. And the next thing that we argue is this 10th Amendment idea, this state rights idea. That, look, we're a bunch of states here and we're sovereigns. You can't come in and tell us how to regulate the lives, the health, the safety of our people. You know, insurance has typically been and historically been and should be regulated at the state level. It's historically been that way. And I'm hearing all this talk about now what the federal government's requiring you all to do. It shouldn't be that way. It wasn't ever intended to be that way because that's broad police power. So that's our other argument. So we go, 26 states. We show up in Judge Vinson's courtroom down in Pensacola, Florida. Big, huge southern courtroom. Beautiful, grand, marble, dark wood. You can just picture this in your mind. The little fans going around real slow, in the South. And we go in there, and you could just sense that this is historical. We got 26 states lined up on one side of the courtroom. Attorneys General, Deputy Attorney General, lead special counsel for the governor. If the Attorney Generals wouldn't do that, there were several states like ours that wouldn't do that. On the other side, you got 8 lawyers from the Department of Justice, all dressed up with their suits and their big briefcases and everything. And Judge Vincent comes out, and he says, and he reminds us how important this day is and how big of a deal this is. And he reminded us that on this day, when we were there for the first time in front of him, on this day we were beginning the celebration of a very important week in the United States of America, and that was Constitution Week. This is the week that we celebrated the founding of our Constitution. And he pointed this huge mural in his courtroom, and we all happened to be sitting underneath it on the state side. And it was that famous mural of the founding fathers signing the Constitution. And he said, we're here to do their business. I mean, it was just historical. And he has asked all the states to stand up and just introduce themselves, Alabama and Alaska and all the way down the line, 26 states. Then he asked the Department of Justice to stand up. They stand up and they introduce themselves. And this is a clash of titans, right? This is the clash of sovereigns here. But it's exactly what the founding fathers wanted to have happen. And the founding fathers said repeatedly, if the federal government ever tries to take away too many rights, the states will push back. That's one of the checks and balances. The states will push back. Why? Because every time the federal government expands, individual rights have to contract. When they tell you all that you've got to be certified or whatever it was, you have to be certified now in order to collect a commission, your individual rights now have just contracted. You can't go out and get a commission unless you follow some regulation of the government. And that's okay. We'll give up some of our liberties, but we won't. But there are points where we don't give up our liberties. And that's always the debate. And so this is the great debate of our day. It is the great debate of our day. It is going to be whether or not Congress and the federal government continues to be or should be a government of limited authority, of limited powers, or whether they're going to have just general police power to basically say we got a problem in this country, we're going to pass a law and fix it. If that happens, then our system of government is gone. You may or may not like that. People debate that. They say, well, what's wrong with that, Mark? You know, we can elect him or not elect him. That's a good argument, but all I can tell you is that's not the constitutional Republican form of government that our founding fathers created. Our founding fathers created a limited government system that were checks and balances. They're supposed to be inefficient so that we maximize our liberties. So we present our oral argument to Judge Vinson. And as you heard, we won. And Judge Vinson, in that case, struck down the law as unconstitutional on the grounds that we had suggested. There are about 30 other lawsuits going on. 5 of them have gone to a decision. I think 3 have been upheld as constitutional. 2 have been stricken down as unconstitutional, including a companion case in Virginia. Virginia likewise sued. They didn't join our suit. They did it on their own because they had a little special statute that they were trying to enforce. So there's 27 states now. Think about that just in terms of historically. 27 states banding together to do anything. You know, when have you heard that? Let alone suing the federal government to strike down a federal law. So just unprecedented times. And Judge Vincent, though, after we argued, issued an opinion, and just was a 78-page opinion, well-reasoned. Everybody agreed it was well-reasoned. And again, these are big constitutional questions, big constitutional federal issues. And there are some judges, though, who have said it's constitutional. But I will tell you this. In every single one of those cases where the federal judge has said it's constitutional, they have recognized what the states have argued. And that is, Congress can only control voluntary actions of its citizens to engage in business. So what those courts have done is, they've all said, and this is a little scary to me, but they've all said, the very act of you making a decision not to buy insurance is activity enough for the federal government to regulate. Your decision not to buy a product is activity that the federal government can regulate. Now just think about that. My decision tonight to go home and not go to bed at midnight, but instead of going to bed at 10 p.m. That's a decision. When we're going to go to bed, we're choosing not to go to bed at midnight. As a result of that choice, we are choosing not to use as much electricity. Isn't that correct? That electricity can have an impact on commerce and the purchase of electricity. Easy to show that nexus. Your and my decision not to put our money in Wells Fargo. I hope there's no Wells Fargo. No negative impact meant here. Or Bank of America. Or our decision not to put our money there is a decision not to deposit money in Wells Fargo. Our decision not to buy a General Motors car is a decision that we choose not to buy a General Motors car. Under the reasoning of these recent federal court decisions and of the reasoning of the federal government, the Department of Justice, our decision not to buy insurance, our decision not to buy a General Motors car, our decision not to buy broccoli, our decision not to buy a health membership somewhere can now all be regulated by the federal government. And we can be forced to buy any of those products. And I don't care what side of the aisle you're on, it doesn't matter. I mean, I think sincere people are on both sides of the aisle. A very scary proposition is the federal government requiring you and I to buy anything. Because all you got to do is now imagine, if you're a Democrat, imagine a Congress that's all Republican and a Republican administration. And they all decide we all got to buy handguns. Now that's going to set some people off crazy. Doesn't matter. Doesn't matter what the product is. The principle is, under the Commerce Clause, Congress can require us to buy a product. It's a dangerous precedent. There are things that need to be fixed in this country without question. Healthcare, one of the things that need to be fixed. This isn't the way to do it. It is a dangerous erosion of our liberty. It's a dangerous erosion of our form of government. Congress could do the exact same thing that they did. I'm often asked about that. Well, what happens if this gets struck down? It's got to go back to Congress. Or what could Congress have done? Congress can have this exact legislation without question constitutional by changing one thing. Change the individual mandate and raise everybody's taxes. That would be unassailable. Congress has broad power in the Constitution to tax and spend. So if they want to if they want to cover everybody, just go sell it to the American people that their taxes ought to be raised. And you may recall that debate occurred during the course of this legislation, and those who passed this legislation and those who were proponents of it went to great lengths to say this was not a tax. That the penalty that would be imposed for not buying health insurance was not a tax. Why? Because politically they couldn't sell it. So go back and sell it some way to the American people, but don't erode the Constitution. Don't erode our form of government. It is the greatest avenue of freedom and liberty in the world. People are not breaking down the borders of other countries and applying for visas and permanent status in other countries to go take advantage of some government program. They're breaking down our doors because they want freedom, they want liberties, they want opportunities. That's what this country stands for. And with God's help and with the help of these courts, and hopefully the Supreme Court, it'll continue to be that way. We now are in front of the 11th Circuit Court of Appeals. We're going to go argue the case on June 8th. And the Supreme Court will ultimately decide whether or not Congress can require all of us to buy a product. And ultimately, I think, whether or not the federal government continues to be a government of limited powers or a government of broad plenary powers is going to basically tell us what we can do. But I implore you, no matter how you feel about this, to do what has been asked here today, and that is to get involved. And I'm going to end with one of my favorite Theodore Roosevelt quotes. And it talks about our involvement and what his views are, people who are and aren't involved. He said this: "It is not the critic who counts." There are all kinds of critics in the world. We all hear about them. "Not the man who points out how the strong man stumbles or where the doer of deeds could have done them better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs and comes short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows the great enthusiasm, the great devotion, who spends himself in a worthy cause, who, at the best, in the end, knows the triumph of high achievement, and who, at the worst, if he fails, at least fails while daring greatly, so that his place shall never be among those cold and timid souls who know neither victory nor defeat." Thank you very much. Yes, Louisiana. Yep, Louisiana is participating with a Democrat governor as well as with a Democrat attorney general. Most of the other states, though, you can always tell there are 7 of us who are appointed by the governor to be special counsel, and those states tend to be they are where there's a Democrat governor and a Republican governor and a Democrat attorney general, and because it's a very political issue, there's no question about it. But from my standpoint, it's a very clean issue in terms of the constitutional question, the legal question. That's really what I focus on, and what I hope that the courts focus on and other people focus on.
The other question I have for you, is there a state right now where they don't mandate car insurance?
Is there a state where they don't mandate car insurance? That's a good question. And I had a reporter actually ask me that question who said, well, Hutchinson, you're pretty hypocritical here. You don't think the federal government can require us to buy insurance. Well, what about states? They require car insurance. What's going on there? I say that's absolutely right, because states have broad police power. They can regulate the health and the welfare and the safety of their citizens. Remember, they just have to pass legislation. They can require car insurance. That's one distinction. Secondly, the distinction on car insurance is you voluntarily decide that you're going to drive. And thirdly, you're driving on public highways. Whereas, contrast that with the health insurance here is Congress, we don't think, has the authority under the federal Constitution to require it, and people are not voluntarily engaging in any activity. It's inactivity. Yes, ma'am. I'm sorry? Cite on that. You want me to give you like an F-sup cite on that? You know what? I don't have that, but I can get that for you afterwards. It's Judge Vinson. I can tell you this. Google a healthcare decision, Vinson, V-I-N-S-O-N. It'll pull it up all over the place. V is in Victor, V-I-N-S-O-N. Yep, it'll pull up. 78-page opinion. Yes, sir.
So is the same legislation being enforced on the state level?
That's right. No problem. As a matter of fact, you may recall, I don't know how people feel or don't feel about Romney, and there's lots of things that happen here, but he's criticized about that. And hey, look, you're running as Republican now, and the Republicans against national health care. What about you? You're in Massachusetts. Well, that may or may not be a good idea for Massachusetts, and it may or may not work. I have no idea. Some people like it, some people don't. But there's no question that the Massachusetts legislature and the governor could do exactly what they did. Again, broad police power, right? They could just pass a law and they can do whatever they want to do. And in fact, that's exactly what the Founding Fathers wanted to have happen. So if you don't like what you have in Massachusetts, move to Pennsylvania.
So, in your opinion, it's not a matter of whether it's a problem or what the solution is, but what is your opinion of the solution?
My opinion of the solution is that, my own opinion is that it's a states issue. And states ought to be able to decide that and make those calls in terms of formulating this kind of a system like they did in Massachusetts. Completely a state level decision. If it gets raised to the national level, I feel strongly in terms of whether I think that this should be regulated by the federal government. But if they tax us, if they just simply say, we think this is good enough, we're going to raise everybody's income tax by 10% or 5% or whatever it is, I have no problem with that. There'll be no lawsuit at all. Yeah. Frank.
Mark, severability, could you just explain
Yeah.
that and why it was not put into?
Sure. Now, so that was a big issue in the Florida case, and it was a big issue in the Virginia case. Severability deals with this idea that when legislatures pass legislation, they can put in a provision that says, hey, look, if there's any provision of this law that is deemed to be unconstitutional or illegal or something like that, just cut out the part that is offending and leave the rest of the legislation there. Well, when Congress enacted the Patient Protection Affordable Care Act, they initially had in a severability provision. And then the final version, though, it was debated, it was taken out. And so what Judge Vincent said was, that to me shows an intent of Congress to either have this whole legislation rise and fall on all the provisions or not. And so when he declared unconstitutional the individual mandate that really fueled the way in which you could pay for this, he said, I think the whole thing's got to fall. Judge Hutchinson, right next door in our sister state, up a ways in Virginia, said, I don't agree with that. I think it can be severable, so I'm just going to sever out the individual mandate, leave the rest of the law there. But Congress could do that. Congress could, today, we could end this debate right now. Congress could say, look, we hear there's too much kickback on this. We're going to leave everything the way it is. We'll sever out the individual mandate. We'll replace it with a tax system or whatever, leave it in place. And then guess what? All of our cases would be dismissed by the courts because Congress could absolutely do that. All right. Well, thank you very much for your time. Yes, Adam.
Sorry. Timeline, June 8th, you're arguing
Yeah.
in front of the 11th.
Right.
Then what do we think in front of the Supreme Court?
And then it'll go in front of the Supreme Court for this next session. It'll be for the 2011-2012 session. All of their decisions will be made by June of 2012. So within about a year, we'll have a decision from the court. And I'll ask a question that maybe some of you had, which is what's going to happen at the Supreme Court? What's your prediction? And my prediction is we win 5-4. We get Thomas and Scalia, and we get Alito and Roberts, and then the swing vote's going to be Justice Kennedy. And the reason we think we get Kennedy is because on the last, in general, the Supreme Court will not question Congress's authority under the Commerce Clause. The last time that the U.S. Supreme Court did that and struck down a law, Justice Kennedy was in that majority. And so we think that he's going to be in the majority as well. So we think it's a 5-4 decision, but who knows? At the Supreme Court, anything can happen. Thank you very much.